Good morning, John.
Good morning, Alibi. How are you?
I'm good.
Good,
Thank,
good.
thank you for being with us today.
My pleasure.
First of all, could you please introduce yourself for our audience?
Sure. My name is John Mitchell, and I am an attorney and mediator here in Los Angeles, California. I've been an attorney for 27 years, and for the first 17 of those 27, I was a litigator and mostly real estate issues here in California. I'm also and then the last 10 years I've been focusing exclusively on mediation in both federal and state court. So I'm on the panel for the federal mediators, and I've been focusing exclusively on federal litigation for the last 4 or 5 years, actually.
You have wonderful experience.
I do, with especially with I guess civil harassment mediations. I have over 500 settlements of those cases, and I think it's an excellent training ground for learning skills because you find parties who are very angry, and it's an idea. Well, we do them in caucus because of the potential temporary restraining order that may be present, but it's a good way to learn what the case is about and to actually it's a way to become an evaluative mediator because you're looking at the facts that they have presented to you and you're going to say, well, are you going to be able to achieve your objective here today? And you ask that question and you say, well, in my experience, if you don't have clear and convincing evidence, you're not going to get it. So it's probably a better idea for you to see if you can work this out. Because a restraining order only lasts for 3 years maximum, sometimes 5 years, depending on your judge. But if you get a mutual stay away agreement, that lasts forever, and so that has utility for a lot of people and makes a lot of sense. So
Thank
I mean, it's mediation is getting people just to listen to good sense, really,
thank
and
you.
to avoid risk. And so that's really what it's about, and that's why cases settle is because there's the risk of loss. And so Daniel Kahneman, the psychologist, he won a Pulitzer Prize, for behavioral economics on the principle that human beings, we like to win, but we cannot withstand a loss. It's really, avoiding a loss. And armed with that information as a mediator, I have a tremendous advantage because I can focus in on the risk of loss and help people find a ground where they can all agree upon. So that's kind of the basics.
It's great. It's always fascinating to learn how person comes to the field of ADR mediation. So my second question, how and why have you come to mediation?
That's a really good question. So as a litigator, you find out that you win some cases you should have lost, and you lost some cases you should have won, and then you can appeal things, and you just keep it ongoing, and so litigation is very expensive, time consuming, and taxing. And not only that, oftentimes, if you're not on the winning side, it's bad. It's just bad. So and I don't like to lose. So I found that when I became a mediator, it's like every case I work on, I never lose anymore. I always win. You know, and so most cases settle. And so, they don't always settle in mediation, but most of them settle most of the time. And the reason is that is because eventually people start to listen and look at the facts and the reality of the situation and come to the conclusion that it's just too expensive, time consuming, and unsatisfactory, basically, to play a zero sum game where you might lose. And Daniel Kahneman told us that we don't like to lose. That's just out of the question. We don't want to lose. So how can we change the game, basically, where we're not in a situation where we face potential risk of a horrendous loss, and where we can find a way to deal with the situation that is the least onerous possible. And so that's why I came to mediation. I don't like to lose. In fact, I like to create what's called a win-win-win situation. So that's where both parties walk away feeling, well, it's not the best thing, but I can live with it. And that's a win-win-win when the mediator brings it home. The other thing is I was involved in early in my career. I was involved in a mediation, a real estate mediation, and it went over several sessions, joint sessions, and we had caucusing many days. It was weeks really, and it didn't settle. So then it went to litigation and it didn't work out really well. And I was like, it left a really bad taste in my mouth. So, while traditionally mediators are neutral, that's true, they are neutral. There's no doubt about it, but agnostic as to the outcome of a mediation. And so this is where bias comes in. My bias is I want to settle each and every case. And if I can, I'm hopeful that they will be able to settle if we put everybody on the right path, because it's usually the better way. It's the most satisfying way to reach a conclusion of the situation. And that's basically what brought me to mediation, is that I find that clients are more satisfied. They pay less money. That makes them happy. They get better results, at least the results they can live with, in a way that we can work it out. And so that's another reason why I came to mediation, or part of it.
Can we summarize it? You came to mediation because you don't like to lose.
I don't like to lose, but more importantly, it has to do with client satisfaction. I think clients, first of all, they have a chance to be heard in a mediation, whereas in litigation, that may be or may not be true. You get on the stand and you don't get to say what you want to say necessarily. And so in a mediation, at least clients can get an opportunity to be heard. And so not only is it faster, less expensive, it's potentially more satisfying for consumers, the clients, basically. That's where I'm at.
So my next question, because not everyone familiar with mediation, unfortunately. Could you please walk us through your typical mediation process, just to get general understanding, general picture of mediation process?
Sure, absolutely. So I consider myself a mixed method mediator. So I'm not only an evaluative mediator, which I am primarily. I also have training in the transformative approach, which is adopted by the United States Postal Service, dealing with employment issues. And I'm also a facilitative mediator. That's what we all basically learned in the very beginning, which is you're just trying to help the parties negotiate, and come to a reasonable settlement. So the way that I open up is an opening statement, and then I basically set the ground rules for what the mediation is about. It's confidential, it's voluntary, and we work it from there. So the first thing after the opening statement is I want to hear from the plaintiff. Why are we here in the first place? What is their story? So I want to hear, but more importantly, I want the other side to hear their side of the story. So there's that. So once we get the plaintiff's version, then we'll get the defense to see if they want to chime in and offer an apology. That happens a lot. It happens frequently. Very, very sorry. And then we go back over to the plaintiff's counsel and let's lay out the case. Let's lay it out, set it up nice and beautifully, and why it is that why is their demand should be met, and especially in the litigation. After we do that part, then we hear from the defense to say, hey, wait a minute, let's look at it from this point of view. Here's our version of the story. So once we get through that, then we go into a caucus. So it's a question of, at that point, my decision is, who do I want to hear from first in the caucus? Now, if I got an offer from the defense, then I might want to go to the plaintiff. If I didn't get an offer from the defense, then I might want to go to the defense and say, let's find out what's going on here. What can we do? And do you really want to settle this, or not? See, because here's the thing. So, time is expensive, especially if you have attorneys on both sides. So if there is no possible way that we're going to reach a settlement today, then I say, well, let's do what you all have to do in order to get the information that you need in order to make a decision on this thing. And let's set it up for a later date. Let's not waste time on this, and let's move on so that I can deal with things that might settle and that you guys can handle your dispute in a way that makes sense to you all. And so that's kind of what we decide. So if we can get an offer, then we get the offers going back and forth and that kind of thing. the counteroffers, and we'll see if we're getting closer and closer. So if we're getting closer and closer and something that makes sense, then we continue on until we see if we can make it happen. And if not, then we're going to cut it short and we're going to set it up for another day if the parties want to do it that way. That's kind of typically how it runs.
Yeah, thank you. And one of the key or essential element of successful mediation is a trust between mediator and parties. Could you please reveal your secret, your techniques? How do you build trust as a mediator with parties?
That's a very good question. So before trust can be established, I have to establish rapport with the parties. The way that I establish rapport is very simple. It's just a question of understanding. Can I understand you? Can you understand me? And as long as we have that going, then we have the basis of rapport. As long as we can communicate, and we can do that. Otherwise, we might need an interpreter. And so then that's a whole different rapport issue. You might have to deal with the interpreter in terms of setting up rapport communication. Can I understand this interpreter? Can they understand me? That kind of thing. So communication, or the ability to communicate, is essential for establishing rapport, and rapport is essential for establishing trust. The way that I establish trust is I am what you call brutally honest. In other words, I'm going to tell people the card whole facts from my perception. And that's what parties need to hear from an individual. That's what they need to hear from me as a mediator and an attorney. It's like, this is my true opinion. And I'm also, let me mention, I'm a judge pro tem. So I actually get to make decisions on the bench for these kinds of things. And not that I, advertise that per se, but it's just, it's like it adds to the ability to come up with, evaluations about a person's position and whether or not it makes sense, and whether or not, it's a viable cause, that kind of thing. So the way that I establish trust is with brutal, and I mean brutal, honesty. And when I say brutal, I'm a proponent of profanity. So I sprinkle my opinions with profanity. For example, I might tell a party, well, I think there's a real good chance that you might get your ass kicked in court. And so that goes to Kahneman's behavioral economics theory about people do not want to lose. They do not want to hear that. And it's persuasive. That's what an evaluative mediator would do. A transformative mediator would not do that. Transformative mediator is going to let the parties do whatever it is they're going to do, but just by mirroring and summarizing and checking in with the other side, which oftentimes is the case if we're trying to maintain the relationship going forward. If not, I'm going to be an evaluative mediator. That's what I am. But honestly, I'm a mixed method mediator. So it just depends on the situation. As stuff that comes out of the toolbox, basically.
Okay, thank you. And is it possible to preserve relationship using mediation? And did you have such cases in your practice? By
Absolutely.
relationship, I mean business relationship, family relationship.
Absolutely. It's about coming to an understanding of what the argument is about, seeing if we can resolve it, and putting them on a path to resolving future situations like this going forward. So I'll give you an example of a mediation I did. It was a civil harassment mediation between a daughter and her parents. She was getting an advanced degree from an Ivy League school, and her parents were paying for it. And she filed a restraining order against her parents because they called her too much to check on her. I was like, this is an unbelievable situation, but true. And so we were able to work it out, but it's just a question of understanding the situation and getting people to understand the oh, is that what they mean situation kind of thing. And from there, apologizing and seeing if we can move past the hurt. We see people move past their hurt all the time. It's called repairing the relationship. It's possible and doable with mediation.
Thank you. It's a fascinating case. Sooner or later, we face with stalemate during negotiation stage. How do you handle such situations where parties don't want to move, don't want to compromise from their positions?
Yeah, well, so people who are stuck in their position may want to deal with play a different game. They may not want to do the mediation. They may want to do the zero sum game. So if they want to play the zero sum game, then please, by all means, go for it. Go forth and prosper, and stop wasting my time, because I'm here to bring this thing to an end. That's my bias, actually, is I want to settle this thing. I want to bring it to a conclusion for the benefit of everybody involved. And if you don't want to do that, if you don't want to play that game, then go play some other game. We're done. That's I don't have time for. I mean, I can spend all day working with a position, but if they want to do something a different way, then I'm not going to stop them. How can I? It's not up to me. In fact, in a mediation, whether or not they settle is not up to me. It's up to them. And so if that's what they want to do, go forth and prosper. And oftentimes I think attorneys don't want to settle because they would like to keep the pipes rolling, keep the money flowing, that kind of thing. And so I can understand that part, but they have to understand their client's position, and they have to accept that as well. So I mean, if that's what I see is counsel, good counsel is aware of their situation, their case, and they will persuade their client to do the right thing a lot of the time. But Ava Abramowitz, she says the best. She's a mediator, by the way, in Washington D.C. She's a professor at George Washington University. She says the best way to persuade someone is for them to persuade themselves. That's who gets persuaded. That's what you get. People have to persuade themselves that this is the right course of action. So.
Thank you. In my practice, I noticed that not everyone familiar how to negotiate. And here's my next question. What's your recommendations for parties who are willing to go to mediation? How to prepare for successful mediation?
Yeah, so in my experience, the best way to prepare for a mediation, counsel and the client, is to understand the case. So if you're going to come to the mediation and discovery hasn't been completed, and you're still looking for information, then there's a good chance that it's not ready to mediate. Parties aren't fully aware of all the facts in their case, and those situations may not be ripe for the settlement, basically. So I'd like to make sure that the parties have a firm understanding of all the facts in their case before we get going, really, in order to achieve a settlement, or at least feel comfortable enough with the facts that they're dealt with on hand to proceed, basically. So that's the best way to prepare. Now, for me personally, as a mediator, I like to get briefs. I want to understand what the case is about. Give me a brief on both sides, just 5 pages maximum of what your case is all about. And so that helps me look up the relevant case law if necessary, and figure out what has to be done.
Thank you. Could you please describe one of your most memorable mediation cases without disclosing any names?
Memorable. I have a lot of memorable ones. My most memorable mediation. That's a real tough question, because I've done over thousands.
People always like to hear some examples from real mediation. That's why I'm asking this question.
Yeah. To be honest with you, I don't have any real ones that are popping out at me right now. It's a question of settlement or not settlement, basically. And when the case doesn't settle, I have to ask myself, is there something I could have done or should have done that I didn't do? that would have helped this case settle. And and then in terms of settlement, I mean, which is something that I achieve or I try to achieve every case. But memorable. I told you about the one where the young lady was suing her parents. That was very memorable. Um, there was a case actually that I did not mediate. Actually, it was a civil harassment case, and it involved. This was memorable. It involved a dog owner, and this dog. It was a pit bull who was aggressive. This is a biter, and so the question was, could we get the owner to agree to keep the dog from biting his neighbor's children? And I wouldn't take that case because you can't have an agreement with a dog. You can't say, okay, Rover, don't bite. You're not going to bite these children, right? You can't do that. And so I said, no. The judge is going to have to hear that one because there's a potential for serious grave harm, and there should be a record on file in case this dog owner needs some time out. Basically, he needs to go to jail, or the dog needs to go to jail for that kind of thing. So I wouldn't take that case. So that's kind of memorable. Cases that I would not mediate.
Thank you. And I have two last questions.
Oh, wait a minute. One other one. This is a memorable case as well. I did a case, and it was a case involving producers of marijuana, and they were in court. This was a small claims matter. This was a contractual dispute, and at the time, it's like, I don't think that you could bring a marijuana case in court. This is not necessarily something that the court can rule on. So I don't think you should mediate. I don't think you should litigate this case. I think you definitely should mediate the case. So it turned out one of the partners ripped the other partner off, in a drug deal. No big surprise, right? And so, but they were able to settle that case. That was memorable as well. So that's a case that definitely should have mediated and should not have been litigated.
Yeah, sure. Thank you. Last two questions. How can we encourage people to use mediation?
That is a really good question. And that's one that mediators across the world are seeking to or grappling with right now. So fortunately, recently there's something called the Singapore Convention, which is something that is to promote mediation globally, which is really what we need. I mean, it's like, let's change the game. Zero-sum game is great and all, and in America, we started off with, dueling. So it was like, somebody gets shot, in an argument, in a duel. That's where we started off. And then we said, well, let's go to litigation. Well, it's time to move on from litigation to mediation, because it just makes a lot more sense to work things out that way. And so how do we get people to move? Well, I guess education is the first part. Certainly for divorce and family issues, mediation is absolutely hands down the best way to handle those kinds of situations, except when you have a situation where a spouse has a business and they can hide assets easily. Then you might have to do some discovery, and so litigation might be essential. But overall and mostly, family issues should be dealt with through mediation. And I think a lot of divorcing parties are learning that that's really a more economical way to handle things. All right, and if they haven't learned the first time, then maybe the second time they'll learn that, second time around.
Yep. Thank you. And my last question for today, in your opinion, how can the mediation process be improved?
Well, I think it has improved quite a bit. With the advent of Zoom, for example, I think that Zoom adds a lot of security for the parties and convenience. So, now we don't have to go to court to do the mediation or go to the office to do the mediation, although I still do both. And Zoom mediations, although to be honest with you, My preferred method to mediate is on the telephone, doing conference calls, to be honest with you. And I've done a bunch of them that way. They're very successful, very convenient. You can go to your mediation in your pajamas and have a successful mediation just as easily. And I think that it tends to focus people on the words, which are very important. It's like, this is what we're talking about here, and there's there's no confusion about the visual stimuli. The visual stimuli might be, you could lie, basically, and you go lie with the words, but at least you won't get confused by the visual on the phone. And I find it very effective. I like the phone myself. So I think that the communication method has improved mediations a great deal. Zoom. I like the telephone myself. We still do personal if necessary. That's okay. And sometimes it might be necessary. So how do we improve it overall? I think it's improved quite a bit.
Thank you. Thank you for your time. Thank you for expert opinion.
Sure, my pleasure.